Hi, y'all, and welcome to tonight's live stream. Well, many people figured it was going to be a much quicker verdict than it has been in the Delphi Murders case against Richard Allen. I'm one of those people. I figured yesterday, Friday verdicts are a magic thing. Typically, juries want to get out, they want to go home for the weekend. And so it's kind of common knowledge that they may make decisions then. But it's not fast. It's now been 2.5 days because they only really had a half day to deliberate on Thursday, all day Friday, all day today, still no verdict. If you're the prosecution, you're thinking to yourself, how hard is this? The man confessed. This seems really pretty easy. They should have clearly convicted him. His bullet was found between the two girls, a bullet that had been cycled through his gun. Why is this taking so long? And if you're on the defense, you're thinking, it seems really clear that they don't have sufficient evidence. They can't really connect Richard Allen to the crime scene. Those confessions were coerced by terrible prison conditions. Both sides are wondering, what is taking the jury so long? Could we have a hung jury? Are they having a hard time deciding? And what happens if the jury can't agree? Those are the very issues we're going to talk about tonight. So welcome into the live stream, everybody. I'll thank the first 5 that are shown, but I got bumped off and had to come back in. So these are probably not the first 5. If you were, write me and I'll apologize. LA, Griffin 2263, Maria Z, BGOG, and Rita Young. Welcome as the first 5 into the chat, at least first 5 I have this go around. And I have so many shout outs. I'll save those for the end, but I have a bunch of shout outs. So what is going on at the courthouse? Let me dive into the first question. What's taking the jury so long to make a decision, and what's happening down at the courthouse? So right now, every day, all day Friday and all day today, dozens and maybe 100 or more people are milling around outside the courthouse. Who's there? Well, it's a lot of people who have been following the trial for a long time. There's a long column of YouTube channel names that's been propped against a wall right outside the courthouse. Probably 30 channels that have really devoted substantial time to the Delphi Murders case, to the case of Richard Allen. Then there are chairs lined up. I would guess more than 30, possibly 40 chairs lined up. And we know only 18 are getting in. So, but those chairs are lined up and people hoping maybe there will be more than one shot. Maybe it'll be divided into 2 parts. Who knows? So everybody's lined up. Media of all sorts, their national media, all the local networks, all the major networks have their local affiliates there. There are several newspapers, including the Indy Star, for example, the Daily Mail out of the UK, but also with the UK, with a US presence. Dateline's there, Court TV is there, the cameras up and down the sidewalk, lots and lots of people. There are also numerous signs that have been set out with messages that range from ones that are anti the judge in the case, ones that talk about secrecy in the case and why people aren't being given access to the case, to ones that just talk about Abby and Libby and say that they want justice for the girls who were murdered. So Richard Allen, of course, is a man on trial for that. Now, at this point during the day, everybody is watching those doors to see, do attorneys come in and out? And today we had an exciting moment. A lot of people thought, this is it. We're about to get our verdict, when Rosie Auger and their legal intern all went into the courtroom. Later, Baldwin arrived, the last attorney for the defense. The prosecutors already have an office inside the courtroom, so they're already there. But none of that actually amounted to a verdict. And after a few hours, we saw all the defense lawyers, or at least Rosie and Baldwin, come back out. Richard Allen was also brought to the courthouse and then taken away in the afternoon. And I'll tell you why I think that is, and even show you a legal precedent that I think explains it. So what is the jury thinking? That's a question all of us have. A lot of times you can get some clues by the questions that a jury sends out during its deliberations. Now, in this particular case, we're not seeing those. The courtroom has been cleared, so we're not getting those questions. Usually it would be in open court. The jury would send a note out. The judge would call the lawyers in open court. It would be read, and the lawyers would argue back and forth about what to do. Sometimes a lawyer might say, well, we can't answer that question, Judge. Or they might say, sure, send out that exhibit if they need it. In this case, we don't even know what's being asked. We don't know what the arguments are. We don't even know what the question is. For that matter, we don't fully know that there are questions being asked. We do know that there are rumors. I'm going to show you one. There are lots of different things that we are hearing, both outside. Let me stop that screen share and add another one for you. I wanted to show you this X account. Okay, by Lily in London. I don't know Lily in London, but saying the jury wanted to see the interrogation video and Libby's video. It could be that they wanted to compare the voices. Now, I also heard that rumor that Lily is talking about, but I was completely unable to track it down. I don't know if Lily in London is right about what documents they wanted. I don't know where that rumor came from. It could be just one of those things that gets started where someone says, I know what I'd like to see. I would really want to see the interrogation videos and Libby's video, and then it, mushrooms from there. It doesn't necessarily mean it came directly from inside the court. My guess is it's more of a rumor, but who knows? So, but why? If they ask for that, why? There are several different directions that could take us. One would be they are interested in the interrogation video because of the fact that it could show, just as Lily in London says, the voice. Libby took a video of Richard Allen, I really need to backtrack on that, don't I? Libby took a video of Bridge Guy, and the prosecution claims that it's Richard Allen. And that video had voice to it. So we heard a man say down the hill. Now, as the defense pointed out in the first opening, it isn't completely clear that the man known as Bridge Guy actually says those words. So there's a lot of doubt in that, but they may have wanted to compare that voice to the voice when he was asked questions by the police before he was arrested. But there are other things that can mean. For example, it could be that they wanted to compare how he dressed, or it could be they wanted to compare how he looked and his weight, because he clearly had lost weight by the time of trial relative to either when the crime occurred and he's accused of having committed it, or when he was interrogated. But another reason, sort of a little more standard, is that the defense asked them, please review the interviews. Please review those 2 police interviews. And there's good reason for that. And the reason for that would be that they were very clear examples of Richard Allen adamantly saying, I did not kill Libby and Abby, and saying adamantly, that I didn't do it. You cannot make me say I did it. I didn't do that. I'm not going to confess to you that I did it because I didn't. And he was adamant about that. It's a very stark contrast to what came later when he confessed. And the defense says there's a reason for that stark contrast, and that's the fact that he had been put in these inhumane conditions within the prison. So that's the distinction that they're drawing. When he was not in those conditions, he was adamant he didn't commit it. And when he was in those conditions and driven to a point of near insanity, he then confessed. As soon as he came out of it, he stopped confessing. That's the line that the defense would like to draw. And so maybe those 2, even if those were the 2, maybe they weren't connected. Maybe they just were 2 things. I know this. I would be insistent on seeing that video that Libby took, not only because I think it's something that everyone owes to Libby. She sacrificed a great deal to get that. I felt like, anyway, watching it, that you could see it seems really surreptitious, like she was trying to get it and show somebody someday what was happening so she could prove what had happened. And it was, in fact, ultimately what began the process of cracking that case. And had she not had that, who knows? Who knows whether anything would have come of it? So I think for that reason alone, it's worth watching. But also, it was so ambiguous. We saw it a total of 3 times, I think, in the enhanced format, and I've forgotten, but maybe 3 times in the non-enhanced format. I don't know which one, or whether both will be allowed, whether the jury will be allowed to see both or just one. But that particular video is critical. One of the witnesses for the state testified to the words that were said on that video, and they were powerful. I mean, they were extremely important. Here's what it was. Abby, according to what the witness said, Abby says, "Is he right here?" And Abby says, "Don't leave me up here." And she's up on the bridge with a man behind her. Libby says, "See, this is the path." Whispers, "That be a gun." Then there's no path here. Now, what I heard there, and I don't believe she said that be a gun. I've already covered that. But what I heard was, there's no path there for me to go to. And she was, at the time, you could even see her phone was looking directly down the hill toward the road that goes underneath the Monon High Bridge. She and Abby and the man behind Abby were all toward the end of the bridge. And she herself was actually past the end of the bridge, looking down the hill at a very steep embankment going straight down toward the road. The man says, "Guys," the girls say hi, which also seems very unlikely, hi, unless there's someone else there. According to the witness, he heard a gun rack. That was then stricken from the record as not being something that he should testify to. And a man said, "Down the hill." I personally would love to watch that multiple times over. It was very confusing in the enhanced version how the man was really far behind Abby and suddenly he was right up beside her, like instantly. It was also confusing because it did sound like Libby was speaking very softly as if to someone near her. And it wasn't clear if Abby was close enough or if it was Abby speaking. The whole thing was just very confusing. And so I also, if I were on the jury, I would definitely want to watch that several times through to see if I can make some sense of it and understand what was being communicated, what was happening, and any clues I could possibly pull out of it. That's what I would want to do. So it makes a lot of sense to me that they would want to know that. So, but like I say, it's a rumor. And you saw it there in the post on X. I don't know. Did they ask for that? But I can certainly see why both of those are extremely important. I thought the interviews were very powerful for the defense. I thought they were right to ask the jury. Watch those again. See what you can figure out from that. So now, but that, because we're not being taken up into the courtroom for jury questions, and frankly, I can really understand that because it would be very difficult to do with all the lines and the process that's going on down there right now. The chairs are set up. They literally have numbers on them. They have numbers taped to them. There's a list. The list has been shown to the sheriff. It's very organized, a lot thanks to Truth Seeker, who we've talked about her on the channel before. She also gave up her spot to me twice, and most recently so I could see closing arguments. It was very, I can't tell you how much I appreciated it, and thank her again for that. But she's trying to organize the group and to create some order so that there's not utter chaos and a rush for the door when and if the verdict comes back and they're letting people go up to witness it. But to do that every single time there's a jury question, if there are many, would be kind of an overwhelming prospect. So I can actually understand where it's difficult for the judge to do that. It would be great if it could be made public in some form, but given the restrictions she's put around access, I can see where it would be pretty difficult. But although we don't have a lot of information about what's going on during deliberations, we have something really unusual here. We have questions that the jury asked during the case. I've not had a case where the jury was allowed to ask questions, but it was allowed here, and it was allowed a lot. These jurors asked a ton of questions. Some of them were just clarification, just smaller things, but there were 4 major areas where they asked a lot of questions and where we can get some leading and understanding of what the jury might be thinking and might be wondering about. So I want to cover that next, what we can kind of tell about the jury's thought process from those questions. And then I want to talk about, could there be a hung jury? And if there is a hung jury, what does that mean? If they can't make a decision, what does that tell us? Where does the case go from here? So first, let's talk about those juror questions. And I felt like 4 categories were really important to the jury. Lots of little miscellaneous, but the 4 primary categories were the confessions of Richard Allen, what they meant, and whether or not what was said in the confessions was prompted by the fact that he had moved into what even the prison acknowledged was psychosis at some point. Is the only reason that he confessed because he was in psychosis, because he was held in solitary confinement and in such poor conditions for such a long period of time? The defense argues absolutely yes, those confessions aren't legitimate. They aren't real. They were part of fake memories that were created, false memories that were created as a result of the psychosis and the stress that he was under because of his living conditions. Now, the prosecution, of course, says, look, these are confessions over and over. And they're not just confessions to guards. They are also confessions to his psychologist, to whom he had developed an attachment, the state argued. And on top of that, add confessions to his wife and even to his mother. And a man, they say, who says he's found Jesus and begins confessing and even confesses to his wife and his mother is telling the truth. That's the state argument. So let's start with some of the questions that were asked and what they can tell us. The majority, in fact, the biggest number of questions were around the confessions. Now, on Monica Walla is the prison psychologist who was working with Richard Allen. And after she testified, here are some of the questions that the jury asked. Can a diagnosis reappear after returning to normal? And there were several jurors who asked something kind of similar, essentially asking, because Richard Allen had that period of psychosis, and the prison will admit it lasted a month and a half. Looking at the medical records and the type of behavior, you could stretch that out pretty easily to 3 months. But there was a March confession that seemed to predate that. And there was another confession in February of 2024. So that's substantially after April, May, June of 2023. So what about those outliers? Are those real confessions? But this particular juror is asking, well, could it reappear? In other words, could you have a diagnosis, say, of psychosis? They don't ask that, but I think that's what they meant. And then you get back to normal and then it recurs. And the answer was, yes, that can happen. Is it expected or normal for a brief psychotic to recur? Was another question. Could this happen? Is that sort of normal? And she said, yes, it can happen again and again. And this is the prison psychologist actually testifying for the state. And they asked, would he know the procedures if he refused meals? Part of the question was, Dr. Walla had suggested that she thought maybe he was being manipulative by refusing meals. He was actually losing weight significantly, and he was skipping meals. And she said she had told him that once you skip 4 meals, the guards must report that. So she said he was very careful to only skip 3 meals, not 4, so he wouldn't get reported. She said that made her think maybe this whole he literally was eating feces, smearing it on himself, doing really erratic behaviors, stuffing his Bible and his discovery papers down his toilet to the point where he flooded his cell. He said all of those things, Dr. Wallace said, she made her think maybe he was just pretending. Maybe he was malingering. And the fact that he controlled the meals he took made her think that as well. So that was what that question was about. And so the juror is saying, well, would he really know that? Would he know that skipping 4 meals gets you reported? And she said, yeah, I told him that. And another question, what is the relevance of grave disability to the use of involuntary injection? And the juror was asking about the fact that he had grave disability, meaning he had major depressive disorder, and in this case with psychosis by this time, and he was given an involuntary injection of Haldol because of the fact that a team of 3 doctors there at the prison met and concluded, yes, he needed to be given that. He was ill enough that he needed that. And Dr. Wallace said, yeah, that's one of the criteria. That's one of the things that we would look for. Another question, and he came to Westville on medications. And she said, yes, he came in on Prozac. The relevance of that is, it isn't as if he first developed a psychiatric problem while he was in prison, which might suggest maybe he made it up. It's not like that. She's saying, no, admittedly, he already had a problem. He had major depressive disorder with anxiety and anxiety before he ever got to the prison. So we do know that it's for real, in other words. Do you screen for delirium as part of the mental status exam? And she said, no, I don't do that. Objective testimony would be helpful. And she said, yes, that would be helpful. When somebody asked, was he diagnosed with anxiety and depression? And I don't think she knew that. It was significantly a long time before he had gotten there. And final question for Dr. Walla was, does the Department of Corrections require complete records, or are they self-reporting? And in this case, it said a lot are self-report. In other words, this witness is saying, well, okay, Richard Allen tells you that he has major depressive disorder. He tells you he has anxiety. Do you check that, or do you just accept what he tells you? Like, what if he left something out, or what if he made that up? And she's saying pretty much a lot of that is self-reported. So you come in and you tell us in the prison, here are my mental health conditions. So that's what she's suggesting. All right, just a second. All right, Dr. Martin, prison psychiatrist. Did oral Haldol continue? So let me back up. Let me give you a little preface to this. Dr. Martin was the prison psychiatrist who was managing the care of Richard Allen. He didn't see him as frequently as the psychologist who even met with him daily, but he did see him, I think it was 18 times over 13 months. And the jurors asked Dr. Martin, did you continue his oral Haldol after June 20th of 2023? And the answer was yes. The reason that's important is the prison and the state are arguing his psychosis was over. He was done with that in May. I think they said May 2nd, but shortly after that. And yet they're continuing his Haldol, which is for psychosis, and they're continuing that after June 20th of 2023. So to me, that's probably a juror who's thinking, you say he's over it, yet you're medicating him for that. So suggest that's actually a pretty pro-defense question, because they noted that Haldol is continuing. So you must really believe that he's actually somebody who is still in psychosis. Otherwise, it would be inappropriate to give him the medication. That's what I think the juror is pushing towards. So that's a pretty important question. Thank you, Tangley Magina. I appreciate that. And thank you, Michael. Ring, ring. You remember, I met Ring, ring today. Hi, Ring, ring. All right. And Ring, ring actually gave me, where did I put that? Gave me a candle, a Libby and Abby candle. I really appreciated that. It's really cool. It was something that was passed out at the memorial service for the 2 girls. So I was really honored to have that. I think it's in my briefcase. I won't search through it during our live stream, but I really did appreciate it. Thank you, Ring Ring. All right, we'll stop there and let me look at the next expert. These are all experts around the question of whether or not the confessions might have been coerced because of his conditions and because of the psychosis that they believe was created by his condition. So there was a defense expert, Dr. Polly Westcott, and there were a ton of questions that the jury asked her, all around this topic. What she was there to testify about was his psychosis and how all of that might have affected him. And for example, here are some of the questions. You stated that he was afraid to leave his cell because of threats throughout the prison. If he had the common sense to be afraid of his safety, would he also have common sense about confessing? You can see that's a very pro-prosecution argument. And do you see how they're written in a way that they're almost talking to each other? You can almost see where there may have been disagreement among the jurors about this whole delirium thing. They were allowed to discuss the evidence during the course of the case. I'm not familiar with that in any case before, but it is a rule in Indiana where the jurors are allowed, as long as they are all together, to discuss evidence right after it's shown to them. So if they wanted to discuss these confessions, they could. And evidently, my guess would be they probably did. They probably, in a round group, they actually discussed it. So some of these questions are really pro-prosecution, some of them pro-defense. I would say this one is pretty pro-prosecution. Did I say defense before? I definitely meant pro-prosecution if I said the other way around, because the question is, okay, if he's savvy enough that he is afraid to go out because he knows he might be in danger, if he's smart enough to think through that, with it enough to figure that out, then isn't he also with it enough to figure out, I probably shouldn't confess, or if I have, then I should act really nutty so that it covers up that confession, so that people think that it was a fake confession, which is sort of a fake upon a fake upon a fake. It takes a few layers to get to that. But I think that's what the juror is going toward, saying, I'm not really buying necessarily that this confession thing is fake. So the next person, if someone had depression and by the way, it's really almost impossible to tell which juror asked which question. So I don't know. This could be all questions from one juror, but more likely it came from more than one juror. If someone has depression or anxiety as a child, would that cause them to commit crimes as an adult? And the answer was, well, it depends on the person. But you can see that somebody thinking, all right, well, if he had this problem, is that the kind of problem that leads to crime? Because maybe then that problem makes it more likely that he would be the one who committed the crimes. Did you watch the police interview of 1022? I thought that was fascinating. I don't know exactly why they asked it. Her answer was no. The police interview to me made it really look like he was very adamant that he was not guilty. And he seemed very calm about it. It didn't seem like he was anxious, like, oh, I'm about to be caught. They're going to catch me out in a lie. He seemed really sure. Nope. I absolutely did not do this. You're not talking me into confessing because I didn't do it. He just seemed very matter of fact and straightforward. So much so that the defense asked the jury, go back and watch those videos, please, because we're convinced that you are really going to be impressed with what you see. So, but the witness said no. She had not watched the police interview. I don't know why they wanted to know whether she had. If you have an idea on that, drop it in the chat, because I haven't been able to figure out why that question was asked. The next, does he have full diagnosis as major depressive disorder with psychosis or full psychosis? And the answer was, it's major depressive disorder with psychosis. It's not just straight up psychosis. So in other words, he isn't just psychotic. Instead, when he is depressed and factors are added in, then he gets psychosis. So, and I can't know exactly what they were thinking about. It could be that that meant something to them in terms of the confession. It also might have been something where they were asking themselves, could he have committed these murders and either not remember or not have known, or perhaps even have known, but just be a person who would do that? It's hard to know exactly what that question means. It could go in any of those different directions. Another question, can objective testing be interpreted multiple ways? She said no. Did medical records prior to his incarceration include testing? So again, this sounds like a juror who isn't really, could be the same juror who said, is this all self-reporting? You know, do they really give you records? So this may be that same juror saying, well, do you get medical records and they have testing? And she said, no. One time they had him rank his symptoms. That was just subjective. So he did not have some kind of test that came in that said, yes, he's been proven to have major depressive disorder. He's been proven to have anxiety. What is the difference between delusions and delirium, she was asked. And she said a delusion is a false belief about something, like could be believing you're guilty when you're not. It's a false belief about what happened. Delirium is where you're out of it. You don't know who you are, where you are, time of day, things like that. So she drew that distinction. There was also a question to Max Baker, who is the legal intern for Brad Rosie. And he testified because he put together all the video from inside the jail. They showed brief excerpts of that to the jury to give the jury an idea for what the prison living conditions have been like, and to show the jury just how significant the deprivation was for him and how difficult the living conditions were. They emphasized that he had been plucked out of a regular, normal suburban life where he'd lived with his wife of 25 years. His daughter had recently married him. Bam, he was stuck into not just jail. He was taken straight to prison, where he was put in solitary confinement, and the conditions were extremely difficult. And they went in detail through these videos into what exactly was happening. They were short, they were brief, just excerpts. He was on 24/7 camera for his isolation cell because of the unaliving watch or risk that he was in through much of that time. So they took excerpts from that. He was also, anytime he left the room, the cell where he was kept, anytime he left, he was followed with a camcorder. So he was shackled. He had something around his waist. He was on a leash. He was cuffed. And on top of that, he actually was followed around with a camcorder at all times. So Max Baker was asked, since you work for the defense, can you confirm if the defense attorney told you to choose the worst segments of video? The reason this was asked was because the prosecution had said, you work for the defense. I mean, admit it, the videos you took were just the ones that you knew were really bad because you were trying to make him look like things were terrible for him because you were trying to get out of those confessions he made. That's the reason you did this. That's more or less what the prosecution was saying. And Max Baker hadn't really been given a chance to fully answer that. It was just a no. So the question was asked again, and he said no. And he had actually compiled videos that included significant periods of absolutely nothing happening that he wanted to show the jury, but the prosecution had objected. And that was entirely true. They had tried to put in kind of like a day in the life of what it was like for Richard Allen. And to be fair about it, they were going to take 4 hours of the day from, I think, 10 to 2 every month on the 15th of the month. In the theory that sometimes he'll be in psychosis, sometimes he won't. It'll give the jury a good overview, and they can watch as he descends into that. And then as he comes out again, they'll actually visibly see that through the video. And they were going to cut it down very short, but the judge disallowed that because of the prosecution objection. So they didn't get to show that. So you can see from those questions that the jury has a lot of issues around that. You can see some that seem a little bit more pro-defense, and you can see some that seem pro-prosecution. So I would not be surprised if the whole issue of confessions wasn't, and whether or not they were coerced, whether they were forced by prison conditions and by psychosis, I would not be at all surprised to learn that the jury is having a difficult time with that issue, that it's becoming significant for them. Another issue that they fought long and hard on is the van, and whether or not Richard Allen could have seen a van, and whether or not that was a fact only the killer could know. It's related to the confessions, because in one of the confessions, one of them given to prison psychologist Dr. Monica Walla, he talked about he was planning to R the girls or SV the girls, and he he was about to do that when, in fact, a van went by. It startled him, and so he decided to kill the girls instead because he was afraid for himself and his family, I assume, if they told what had happened. But so it was seeing this van that startled him. So the prosecution set out to show, yeah, Richard Allen actually could have seen a van. It became one of the biggest, hardest fought facts in the case, even though it's relatively small. The question was, did Brad Weber drive straight home after work or not? That's really all the question is, but it is of extreme importance in the case because of the question of whether this fact, the van being there, was a fact only the killer could know. Was that a fact that Richard Allen only knew because he was right there in the middle of committing this crime? Or could he have thrown it in somehow? It seems so specific. So in this case, Steve Mullen was asked, he had been talking about missing evidence and that sort of issue. And he was asked, why would anyone discuss the van prior to Richard Allen's confession that a van scared him? And here is what the issue was. The prosecution is saying this van scared him and he couldn't have known in any way that there was an issue about a van. How could he know that somebody who lived on that road, it was really nothing but a driveway to one or two houses, that somebody actually had a van and actually might have driven by at that time? And so how, if he could not have known that beforehand, then he must be the killer. That's the prosecution argument. And the defense says there were lots of references to vans in this case. So he had the discovery in the case. All of these facts about the girls, and what he was going to do to them, all of those facts could have been just things he learned from seeing what he was documented in the discovery that was sent to him. The discovery is documents, it can be depositions, it's the pieces of evidence that are being collected. In this case, the state had plenty of evidence that they were turning over to the defense. So he easily could have seen photographs of the crime scene. He could have seen the video Libby took. He would have known about the bridge. There are a lot of facts he would have known, but what about the van? It seemed different. So the witness was asked, why would anyone discuss the van prior to Richard Allen's confession that a van scared him? Like, what would it have to do with anything? How would that even possibly be in the discovery? And the witness, obviously said he didn't know, but under questioning, Baldwin, one of the attorneys for the defense, got out a couple of questions like, well, it could have been that van that was giving out candy nearby the very next day, or it could have been that van driven by a man named Aaron, and that's as far as we got on that question. He was trying to suggest, because there was no other place it got put in, that maybe vans have been discussed throughout the discovery, and somehow that's how he knew about it. That's the way he knew about it. I can't answer that question because they never actually gave us specific evidence about that. We don't really know what it was that would have led anyone to believe a van was involved. There were references to it, apparently, and Dr. Monica Walla, his prison psychologist, had seen a lot of information about the case. She had been following it on true crime channels. So had she seen it? Had she mentioned it to him? That was what the defense was trying to suggest. So as I said, the key issue, and let me thank you, Susan. I appreciate it. And I want to thank Christy and Irene. Thank you both. And Stacy, moved to a new home, but present. Well, thank you. I appreciate that very much, Stacy. All right. So Brad Weber is the person who lived on that road that went directly under the Monon High Bridge. And road is a fancy word for pretty much a dirt driveway. And he lived on that dirt driveway, and it went directly under the Monon High Bridge. So you can see if the girls had been forced down the hill and were right there, it could be, in theory, near that road. So the prosecution looked at when he clocked out of work, which was 2:02, and they looked at when he got home. He testified that he drove straight home. And the prosecution estimated, okay, that means between 2:27 and 2:30. Well, that would fit in fairly well, although I've taught several times, and I'll do it again. I'm going to do the timeline in probably my very next video, whether it's at the after a verdict or not. But I think I'll cover the timeline in some great detail, and we'll look at sort of a deep dive into all the times and how they fit together and what they show us about the case. And I've talked about how really tight the time frame is. It's 19 minutes from the time Libby takes that video of Bridge Guy to the time Abby, well, at least Libby's phone is lying in the clearing where the girls' bodies are found. So it's really fast. So is that possible? Is that too fast to be done? We didn't hear a lot about it in closing, but it's very tight. We'll cover all that in the video where I'll cover the timeline. By the way, if you would, I always forget to say this, please be sure to hit the like button and subscribe, because you aren't going to want to miss that timeline that I'm going to be talking about. So Brad Weber had apparently initially in a conversation with police outside the driveway to his home had told them he came straight home after work. However, then he was interviewed by the FBI along with a police officer from the state. And the two of them interviewed him. And apparently he told them he didn't come straight home. He told them first he went out, he serviced his ATMs, and he came back. So, and then here at trial, and when they interrogated him before trial or asked him to come in and talk to them, he said that he went straight home. The defense spent a lot of time trying to get in some evidence about the fact that he had gone not straight home, but gone out to service ATMs that he owned. These are ATMs like you would get cash from, and he would service them, by which he meant if they were broken, I'm sure he would fix them, but he would also put cash in so that people could pull the cash out using their ATM cards. So the question of whether he came straight home became all important in the case, even though it seems like a small detail. And he's not even the person being accused, at least at this time. So there were questions early on where they took his gun and tested it and so forth, but he's not at issue in this case, and he's not charged or, as far as I know, a suspect currently by the prosecution. So they asked him questions around this. Do you know if the ATMs would have photo or video of when you were servicing your ATM machines? And he said they might. Such a great question, by the way. I was like, wow, that's really good, because good point. Would any of that exist now, 7 years later? Chances are that it wouldn't. It probably would have been overridden, but it was a great point. How far in advance do you have to order cash for the ATMs? That would be another way that they might show, yeah, the week before he ordered cash, so maybe he would have serviced his ATM that day. What is the process to clock out of work? He says you use a badge to unlock the turnstile. So that's somebody thinking, could he really get home that fast, 2:27 to 2:30? Let's look at that. What driveway do you use to access your home? The one by the Lieberts that goes under the Monon High Bridge. So there are people fishing around for, now, is he really going to be there? Is this fake? And then there are people asking, could he be out servicing the ATMs? And is there any way we could prove that? They asked, do you drive under the Monon High Bridge? He says, yes, that's the route he would normally take. And do you typically go home before servicing the ATMs? And he said, no. If he's going to service the ATMs, in other words, he would go straight and do that. So you can see they're thinking all around that question. Okay, can we figure out for sure whether or not he was there in that very limited time frame right before just 2:27 to 2:30 is the time frame, and by 2:32 Libby's cell phone is lying in its spot right where Abby's body is either currently lying or about to. I don't know which, and I don't think the prosecution has said which, but we know her body was found on top of that cell phone. It was phone, shoe, Abby, in that order. So could she have been already dead by 2:32, or at minimum, the phone, the girls and whoever the killer was had already arrived in that place, assuming that's when the crime happened, which is the state's theory. So they're asking all kinds of questions around it. Brian Harshman was asked, do you know how many vans travel down Brad Weber's drive? And he said, well, the drive doesn't go anywhere else. He said, do you know how many vans travel down the road Brad Weber's drive is connected to? Well, the drive doesn't go anywhere else. So if it's going to be a van, it's going to be Brad Weber's, basically. Cheyenne Mill, did you see or hear any vehicles on the road under the bridge? And she said, there's not a road, which probably confused the jury no end because there is a road under the bridge, but it may be difficult to see. If 3:49 was the end and 3:55 was the beginning, did it take you 6 minutes to go the length of the bridge? She said she figured it was roughly 10 minutes because they weren't all the way at the end when she took, I think it was a photograph or something that gave them a time frame. I missed one. I should have put this up on. I'll finish up with this and then I'll add something to what we talked about before. So you can see lots of questions around that van. They're really thinking about the van. What's happening with the van? Is that a real fact that proves that Richard Allen's confessions are true? Because would there have been any other van, and would the van have been there at that time? In which case, maybe Richard Allen's telling the truth when he confesses. So moving back up to our confessions, here's a couple of questions I had in the wrong spot. Dr. Stuart Gracian was asked, do you believe psychotic behavior can go back to normal after induced in solitary? And he said, yes. And said, do you believe a completely normal person can become psychotic after 6 months to a year in solitary? And he said, absolutely. I've seen it happen. So those both, that the answers anyway would be pro-defense on that. So those are a couple of areas we can tell that they're going to be arguing over. And there were two other issues I want to talk about. One is ballistics, because there were a lot of questions for the defense expert on that sort of give you an idea of where the jury might be struggling or where it might be headed. Same is true for the cell phone expert who talked about the unplugged headphones. One of the very few complete surprise facts that came out in trial, not one people had known about in advance, that after the state believes both Libby and Abby were dead and Richard Allen had left the scene, after that, according to Stacey Eldridge, there was headphones were plugged into the cell phone, or at least there was activity on the place where the headphones would be plugged in. So something was plugged in or done there. And then later, still, before the bodies were found, it was unplugged. The defense says, well, that only happens one way. That only happens if somebody is plugging headphones in and unplugging them. So what that means is that those headphones are being held, the phone is being held by a person. That means Richard Allen's not the killer, because if the phone is still being held by a person and Abby's not on top of it yet, that means Abby's not dead yet. So that's the thinking of the defense. It was a very important fact. And some of the questions that the jurors asked showed that they thought it was important too. And here are the kinds of things they asked her. Did you ever write your own report on the timeline events? And she said, no. That bothered them on two different experts, that the defense had not gotten them to write a report or to sort of finish out some of the research. And that was of concern to them. So then they also asked questions around whether or not some of the things that she was seeing could have been related to Libby's iPad. If Libby's iPad was linked to the cell phone, maybe somebody was working on Libby's iPad or doing things with it, and it was registering through syncing to the cell phone. And she said it in theory, but she didn't think that syncing was involved in this case. Would water or moisture affect movement? She said she doesn't know, but one of the issues is that there frankly are not a ton of steps that registered on the phone before they reach this place where the girls are found. And alternatively, for the defense theory that the girls may have been taken somewhere, that's not registered in movement either, nor is, say, steps from the cemetery down to where the girls were found. So frankly, it doesn't fit either theory. Frankly, the steps and some of the issues around movement really don't fit with the defense theory or the prosecution theory. They're frankly confusing. So here's one of the jurors trying to figure out, okay, what would be an explanation for this? And asked, would water or moisture affect movement? So we feel like probably the prosecution says, I guess the defense would disagree with this, but they may have crossed the creek. The evidence for that would be the fact that Abby had wet jeans and a wet shirt, both a shirt underneath and a sweatshirt on top, and they were wet to a line, is what we were told. So they're asking, well, would water or moisture have affected the ability to detect movement? Maybe if it got wet, it was moving around and we just aren't able to tell it. But the witness said, I don't know. And would water affect the port or the plug-in for earbuds? And she said, I have no knowledge that it would. Again, asking the question, okay, maybe that moisture and maybe if there's moisture in there, it's registering as if headphones were there. We later got an answer from the witness on rebuttal for the state who came in and said, I Googled it right now in the hallway while we were on break. And it says, Google says, AI says, yeah, sure, it could be moisture or dirt, which I could not believe that came in. That is really inadmissible. A Google search in the hallway is not admissible. Can you tell whether the iPhone was in silent or ringer or vibrate? And she said she didn't look. I'm not really sure what that might mean, except for maybe the idea that somebody was trying to prevent sound, and which we were told carries in that area. So people there on the bridge while the girls were being attacked, perhaps they would have actually heard this. Maybe that's why they were asking that. Is there a device that could be put into the port to scramble it for a period of time? Which was a brilliant question. And the witness said, in fact, she searched for that and didn't find a device like that. Obviously, the thinking of that juror is, if it's bothering that juror that if the girls were taken somewhere else and then brought back during the period when the search was called off, because the search was called off between 2 a.m. and 7:30 a.m. They were back out in the area searching. Could the bodies have been left there overnight during that period of time? The defense says there's some evidence of that because at 4:33, suddenly Libby's phone downloads 15 SMS messages. The defense says there's only one reason for that. There's only one way that happens, and that's somebody turns the phone on, and that's why it registers that. And since Abby's body is on top of that phone, that means Abby and Libby are still alive at that hour. Now, obviously, the state believes something different. But as far as this question, the idea behind this is, well, okay, if Abby and Libby were carried off somewhere, say they got in a car down the hill and they were taken somewhere, why isn't the phone showing any movement? It might not register being in a car, but it might register location, or it might register something. And then the phone has to be walked through the woods to where the girls were found. So there really ought to be movement later on. So they were suggesting maybe a device got plugged in to mask that. Is there some kind of CIA level device that you could plug into a phone so it won't record steps or data related to location? And so apparently the witness thought of that too and said, well, I looked for that and I couldn't find it. So I don't know your answer. But you can see where that's a witness who is taking very seriously the defense idea that the girls were taken somewhere else, that they were not immediately murdered that afternoon right there in the area. And that would mean it could not be Richard Allen, because they acknowledged that Richard Allen left and didn't come back. One witness said maybe he came back, but others said, no, we believe he did not come back. He left and that was it. So another question, would you be able to review his location data if you had his phone? This is obviously a witness who's bothered by the fact that the one phone not available to law enforcement when they searched his house was his 2017 phone. But the witness is going to say, would you have to have the phone he had? Sorry, not the witness. The juror is going to ask, would you have to have the phone he had in 2017? The answer is no. The witness said, no, you wouldn't actually have to have that phone. You could still maybe get some of the data. Probably not all of it, but some data might still be available. The witness didn't say that. I'm saying that about probably not all of it. The witness was asked how common was the provider that Richard Allen had, Ting, in 2017. She didn't know. I don't know what the reason for that one is. If you have an idea, put that one in the chat too. Are there any other ways or apps that register movement other than Apple Health? And did Libby's phone have these tools? And the witness said, I didn't look. So the only thing she looked at was the Apple Health, which had been pulled out by the prosecution. She didn't do separate work on her own. So you can see the back and forth there where jurors are thinking, okay, yeah, I'm really considering the defense argument, but wait a minute, what about this? And you can really see the struggle to understand some of these facts being pulled out by the defense, some of the arguments the defense is making about headphones and times when the phone was appearing to be used or at least turned on at times when it should have been impossible for that to happen. And how do they reconcile that with the lack of steps? And you can see where they are struggling very hard in those areas. So this is yet a third area where they could be really having difficulty and where they might be having disagreements among themselves or even just trying to figure it out as to exactly what it is. And the fourth area where I felt like they had some real questions and issues related to ballistics. There were clearly some jurors who understood a good deal about ballistics and asked very probing questions from the prosecution witness. But those were more understanding. Then much of the case is over and we get to the defense expert on ballistics, and they had some very probing questions for him, and those are the ones I wanted to talk about. Here's one. Would removing or disassembling, etc., change the location of striation, and would you have to test it? Would you have to test in all iterations to compare? So you can see this is a juror who is really knowledgeable in this area and is talking about would this have changed the location of the striations? What about if you took the phone apart? Basically, I think what they're asking is if at various stages he's cleaning his gun, he disassembles it. If you have a striation, and for lack of any here, will it maybe move over here? And you have to keep testing it and taking it apart because you might miss. It's over here, but it really would have matched this if only it hadn't been disassembled. It was the disassembling that rotated it or moved it. And she said, no, that wouldn't happen unless there was some kind of damage. Do you know if the manufacturer tracks subclass characteristics? So this is somebody who's really been tracking and following, trying to understand. She said, no, they're microscopic. So it's not something that the manufacturer will put out a list. We have the following subclass characteristics. Is there a reason you didn't verify by conducting your own analysis? Again, that bothered the jury on more than one expert. And the expert said, well, I did what was requested. The reason that is significant, I think, is because the most likely reason that the witnesses did not do that is it's quite expensive. It takes a lot of money to get the expert to do the additional work, to write a report, in this case, to analyze the bullet and determine whether or not this particular expert believed it was true that the unspent cartridge matched Richard Allen's gun. It's also risky because what if that expert concludes, yep, I agree, it matches? Then you can't use that expert. You wouldn't offer that expert. And if you would then need another expert to do the more minimal testing or non-testing, the more minimal conclusions, because the next question was, well, would it have helped? Would doing your own analysis have been more conclusive for you to look at the gun and look at that unspent cartridge? That was the unspent cartridge found between the feet of Libby and Abby. And it was the main reason that Richard Allen was arrested. Once that cartridge was found right at the time the bodies were located, as they were pulling the bodies, they were documenting the bodies there lying in the woods, and they were taking photographs of that. They ran a light across it in order to look for blood. One man wasn't wearing glasses that would protect your eyes for the blood and would enable you to see where the blood was. He wasn't wearing those. And so what he saw was a bright glint saw it more than once. Well, wait a minute. Went over there and found this unspent cartridge pressed down into the earth, nose first, between the feet of Abby and Libby. So that particular unspent cartridge was then traced by law enforcement back to a gun they found in Richard Allen's home. So when they did a search warrant for his home, they pulled this gun. They then tested it and compared it to the unspent cartridge. Now, there's lots of issues around that. For example, and they're going to ask about this. The cartridge found at the scene was unspent. That meant it hadn't been fired. It had been loaded and unloaded 3 times, they said, but it hadn't been actually fired. Well, when they loaded and unloaded not 3, but 6 times into Richard Allen's gun, they weren't able to compare the two. They didn't match. So they then fired a bullet from the gun. And then when they put those two together, they said, yep, now these match. Now the cartridges match. And that bothered the defense. They said that's illegitimate to do testing when you're comparing apples to oranges, unspent cartridges to spent cartridges. So back to the questions from the jury. They said, would doing your own analysis have been more conclusive? He said, well, it's hard to say. I could have said I agree with her, or said, no way, I don't agree with her. My conclusion here is that her documentation doesn't support her conclusions. In other words, what she has right here, the photographs she took, they don't show those marks, those striations, those connections. That it doesn't match. It doesn't show what she claims it does. So that was all he looked at. Would it have been better if he had studied the bullet and found it doesn't match the gun? Yes. But he's saying right here, it's possible I could have studied it and I concluded that it matched. I could have agreed with her. Do you believe using 2 runs of 3 or 1 of 6 would be enough to come to a sufficient analysis? And the answer was CMS would give you either one. Super technical. I just throw it to say some one or more jurors are really tracking with this, and they will be the leaders on this issue. So whatever they think about the ballistics, everybody else is going to believe. If they say, yeah, I've listened to it and this is legitimate, I think that's what the jury is going to believe. They may then struggle over confessions. They may struggle over whether there would be some other reason the cartridge could be there. Or it could be that they say, well, I don't know about that. It doesn't sound right to me on the unspent cartridges. But what I know is these confessions are fake, and he seemed like a guy who seemed legitimate. He did not seem like a guy who wanted to admit that he had done something wrong. So who knows? But if they're dividing down over issues, I think these are some of the key ones. And I think this is showing us one juror is going to have very firm opinions on the ballistics, one way or the other. And I think it's likely to be pro-prosecution based on some of these questions. So ask the witness, are you a certified firearms or tool mark examiner? Yes. Would individual marks be lighter or darker with manual cycling? Essentially trying to ask, okay, if trying to compare that apples and oranges, like if you have one that's the unspent and one that's the spent, what would you see? Would it be lighter? Would it be darker? I don't know if they were planning to look themselves and trying to get some criteria. Maybe they could figure it out. And the witness said, well, it can change depending on how much force you rat the gun with, that sort of thing. Did you look at subclass marks of the cartridge? Said, well, I can't really determine that from the photos. That backed up a point that the prosecution had made, actually. And they asked a couple more very, technical questions. And then one, are sequential serial numbers of guns within the same lot, assuming there isn't a change of serial numbers? So thinking, okay, we're assuming that there's this subclass of guns that have certain characteristics, but what they mentioned how there would be a bucket of parts and they would put a bucket, apart. Well, that means there are going to be a lot of serial numbers that are mixed up. So is it really all that easy to tell these subclasses? It's a complicated question, again, by one of the jurors who's tracking it. So one of the ones, though, that was most hostile to the defense, really pro-prosecution, this witness was asked, are you aware, Oberg, that's the prosecution expert, Oberg's findings were confirmed by another party. Oberg worked for the state. Her supervisor came in and looked at what she'd done. She said, I believe this unspent cartridge matches Richard Allen's gun. And her supervisor came in, looked over her work, said, yep, I agree with you. So what I see this as just a telegraph. This is this witness saying, note, everybody, Oberg said that her findings were confirmed. This guy hadn't even done his own testing, and her findings were confirmed. And this guy isn't telling you that he disagrees with her. He's just saying she didn't document things properly. Her documents don't support it, but they were confirmed by another party. So I feel like this is this juror communicating to other jurors. Reminder, her findings were confirmed. So they're really true and accurate. So to me, there are at least some jurors who are very likely buying the prosecution argument about ballistics. That's what this says to me. At least some jurors believe that. Are you aware, again, are you aware, as if this expert may not know things. The only real reason for the are you aware is, I think, to talk to the other jurors. And I'm assuming they must have been talking about this in their groups. Are you aware the ejector on Richard Allen's gun had a recessed portion that caused individual marks? And the witness said, they all have that. Is it normal practice for you to not issue a report? And she said, yes, about 50% of the time. And they asked, what are the chances a cartridge at the scene would have the same subclass markings as a fired cartridge from Richard Allen? And she said, I don't have stats for that, which in fact was kind of the whole point of what the prosecution, of what the defense was saying, that you can't compare those. There aren't stats to support that. That was what I think the defense wanted to argue. Their expert on that topic was kept out. So they did not fully get to argue it. They argued it in part through their questions. All right. I am now where we finished that part where I talked about the jurors and how I think their questions sort of suggest there are 4 areas where they're probably going to differ. And I think those areas, if they're having trouble, if they're disagreeing, that's where it's going to be. It's going to be on those 4 topics. And we already know that based on their questions. We can already tell these are areas where they're going to struggle because some of them seem to go one way, some go another, and there seem to be real questions around it. I also want to talk about, okay, let's say they're having trouble. What happens? Let's say they're having difficulty figuring it out and they disagree. Okay, now what? What happens if they can't decide that? So, and I want to show you a few things. Let me say thank you to a couple people. Stacy is a new member and already gifted another Lawyerly membership, paying it forward. Thank you, Stacy. I appreciate that. All right, so Kelly is talking about a real issue of the photo of Abigail at 2:07, where there's not Bridge Guy in the photograph. And then at 2:13, actually, Kelly Jane, there were 2 different pictures that were shown during the course of that video. In one, he's a distance behind Abby. He's not right there. And in another, he's really close to her. So it was kind of both in the course of that one video. He's right with them. So he was double their speed. Are we sure Bridge Guy wasn't coming towards them on video? I really think that if they're looking at that video, I think that's wise, because I found it very difficult to interpret. I wanted to sit down and look at that and look at that and look at that until I really felt like I had some sense of what was happening, because it was confusing, shown very quickly, and disorienting. When you saw it without the stabilizing they'd done, it's kind of like this. It's all over the place. It's showing down the hill. It's showing him. It's showing, it just moves a lot. The definite impression I got was that she was trying to conceal the fact that she was taking this because she thought somebody might stop her or take her phone. That's the impression I got, and hence all the movement to it. Now, when they stabilized it, it looked really different, but it also looked like almost like it was spliced or something that happened. And I would really like to know more about that. I could not tell in the quick view we got. And remember, in the gallery, we're kind of to the side too. At least the jury had a front on view. So all of that, I think, huge question. Oh, thank you, Sparky23. Yes, it does look like I'm here for a few more days, at least 2, right? So it's a lovely place to be. I have to say, Indiana is a very lovely place. Thank you, Carrie and Luke. Here again tonight. I appreciate that. All right. didn't the prosecution ever actually say, and I'm going to get to our point about what's going to happen next. Give me just a minute to answer a few people. Inigo is asking me, didn't the prosecution ever actually say that the audio and video of BM, who is Brad? Who is BM? I'm trying to think. Bridge Guy, I got that, are in sync and not laid over each other. Bridge Guy is still passive, not brandishing. Yes, I will say Bridge Guy in both of the pictures is behind her, but you can't see anything. I did think Abby comes off that bridge really kind of fast and kind of like this. And I wondered, I wondered, did somebody push her from behind? Because she kind of comes off quick. Could have been just she was moving quickly because she wanted to be with Libby and away from whoever was behind her. It's hard to know. And it's hard to understand how they already seem to be afraid, even though the guy is pretty far behind Abby. And either Abby or Libby is talking, but they're talking kind of softly as if someone is right beside them. But Libby and Abby are pretty far apart, and Bridge Guy is nowhere near them. I'm just telling you, the whole thing didn't make a lot of sense. I really wanted to look at that and look at that and look at that. It was very confusing. All right, Kathy Crandall, thank you so much. I appreciate that. Big Apple Hoosier, is it true he confessed the day before his psychosis started? So he actually first confessed, and we have I did a timeline on that too, on the confessions, because I think they're critically important. His first confession was actually in March, and they didn't diagnose him then. There are some behaviors around that could suggest he was already in psychosis. So I think it's possible, but it isn't directly related to it happened beforehand. It was in some documentation, and then it's later on that he becomes more severe, that the symptoms become more severe, and that he has some confessions to his wife and mother. So timing wise, I don't think his psychosis could possibly have been from his wife and mother rejecting his confession. He was already having tons and tons of symptoms that you could see. And he had confessed all the way back in March on one occasion. It was very vague, but it had happened. Angie Lee, thank you. Barbara Bradley, I appreciate that. Elf asked a very good question. Doesn't the phone data itself show the steps and floors don't add up? I think so. And when we go through our timeline, I want to look at that very specifically, because to me, that timeline laid over the steps, including the steps, it seems really odd. And I felt like it could be with simple math, you could prove that this was or wasn't possible. Either that's the exact amount it would take to get to where the scene was, or in fact, there's no way you could get two girls across the creek and to the scene in that amount of time with that number of steps and only 2 floors. In fact, the 2 floors seems pretty impossible. They're 65 feet up, and it's 10 feet of elevation change per floor. That's 6.5. And it looks like at least a little bit upward for where the clearing was. I saw some photographs of that today, maybe not as much as I thought, but it still seems like it ought to be more than the 2 floors. So we'll go over all of that when we do our timeline. So be sure to hit the subscribe button so you'll get the notification when we do that. Order in the court, asking if Brad came right home, there'd be no reason to mention ATMS. I'm not sure what ATMS is, but I'm sorry. I'm not very good with acronyms, as you can tell. I missed 2 tonight. Y'all are going to have to spell everything out for me, except for SV. If y'all would please put that. Other than that, yeah, I don't know. Okay, Kathleen. Thank you. I appreciate that very much. And I'm going to stop right there, and we are going to dive in, and I'll come back. Don't worry. I'm going to come back and get questions, and we'll do questions at the end. But I want to talk about what happens if the jury can't decide. And I want to talk about 3 different things I found. I am not an Indiana lawyer, so I tried to find some Indiana lawyers who were talking about this, and this is what I found. Let me stop that screen share and add another for you, so you can see. Okay, first of all, here is an Indiana rule. If the jury advises the court that it has reached an impasse in its deliberations, the court may, but only in the presence of counsel, and in a criminal case, the parties, don't worry, we'll unpack this if it starts to get too long and run on like lawyers do. Inquire of the jurors to determine whether and how the court and counsel can assist them in their deliberative process. After receiving the jurors' response, if any, the court, after consultation with counsel, may direct that further proceedings occur as appropriate. So unpacking that. So if what happens is the jury comes to the court and says, we can't agree, we're at impasse, we cannot reach a conclusion, the court may. That means, that's in legal terms, may means can, doesn't have to, up to them. The court may, is allowed to, doesn't have to, inquire of the jurors, ask the jurors to determine, is there something we can do to help you? It's whether and how the court and counsel can assist them in their deliberative process. I like that because of how open-ended it is. What if this jury said, we want to see the scene? Wow, that would be really great. And we want an Apple phone with us when we go. As you know, the defense initially asked for that. The prosecution opposed it, and the defense withdrew that request. But what if the jurors ask for that? What would that mean? It would be interesting, to know what they might ask for there. And it seems pretty open-ended. What if they say, we need the witness to come back on this topic? It seems very open-ended. I've never heard of that before, ever. I mean, evidence is closed. There should be nothing more. And yet they're asked whether and how the court and counsel can assist them. So very, very curious. It doesn't say assist them with more evidence. It says assist them in their deliberative process and their decision-making. And going back, so how's it done? Has to be done in the presence of counsel. And in a criminal case, the parties. In other words, Richard Allen has to be there. His attorneys have to be there. The prosecutors have to be there. And it can't be done other than that. And so that could theoretically explain why Brad, Rosie, Baldwin, Auger all showed up at the courthouse today. The prosecutors would have already been there, and why Richard Allen was brought in. I kind of think it's not quite at this level yet, but that's something that could have happened. It certainly would fit with this if it's possible, in other words. And then after receiving the juror's response, if any, the court, after consultation with counsel, may direct that further proceedings occur as appropriate. So in other words, they'll all get together, put their heads together, and figure out what to do next if the jury's having a really hard time. But I do like how it really looks at problem solving, kind of, okay, is there anything we can do to help you? How about you need to see some evidence? How about you want to look at this or that? Let's figure out what we can do. So I think that's super interesting. Now, I also found, let me stop sharing that and add another one for you. Give me just a second. I am looking now. Trying to figure out. Okay. So this is not from an Indiana attorney. I'm going to, Kathleen, thank you. I'm going to take that off. But it's the Allen Charge Project in Indiana. Now, if you followed the Karen Reed case, you're probably familiar with how I talked about the Allen charge. Allen was the name of a Supreme Court case, and it's also known as a dynamite charge. So when a jury is having a very hard time making, making a decision, sorry, I should drink some water. When a jury is deliberating and they aren't deciding and it's kind of dragging out, and they come to the judge and they say, we can't decide, what pretty much nobody, well, the loser would like this, but what ideally everybody wants the jury to go ahead and decide. Think about all the work that has gone into this by all parties, and prosecution, defense, all the witnesses, the judge, the jury. They've been here a month. They've taken a month away from their families. All of the people in the media, all the people watching, a lot of time has gone into this for the public and also for the people involved in the case. And it's expensive. We know it's already cost $4 million based on some work done by WTHR, which collected that data through some FOIA requests. So it's actually cost, or it's going to cost the the government that much, Carroll County, I think specifically. So if there are those kinds of costs involved, ideally, you want the jury to make a decision. And so one of the solutions to that was approved by the Supreme Court is it's okay to give the jury a charge. And the charge says, get back in there and try again. Don't assume, and this is, I'm talking very vaguely, but don't assume that there's some magic jury out there that's going to be able to decide. You should try to get in there and see if you can resolve this. Some people believe that's kind of pro-prosecution because it's more likely that people will then say, okay, all right, yeah, I guess he is guilty, than the other way around, that they'll move to, okay, you're right, just let him off. In any event, that is something that's permitted. That's federal from the Supreme Court. But different states do different things around this. It's allowed constitutionally. It doesn't violate the rights of the prisoner, of the person accused. But here's what this particular blog talks about. Evidence Prof blogger, he's from South Carolina, so also not an Indiana lawyer, I presume. He talks about what the cases are in Indiana, that the Indiana case regarding it is Lewis versus State. And in Lewis, Tony Lewis was charged with burglary and theft. The Lewis opinion is sparse on details on when that Allen charge was given, he says, but it doesn't even lay out the first paragraph, but it does note the second paragraph. There is no reason to believe that the case can be tried again any better or more exhaustively than it has been. There is no reason to believe that more evidence or clearer evidence would be produced on behalf of either side. So the Supreme Court of Indiana said that we agree with the Court of Appeals, because this is being appealed up. It's gone from the trial court to the Court of Appeals. Now we're in the Indiana Supreme Court. We agree with the Court of Appeals that even though the second paragraph of the instruction is of a general nature, it still dangerously approaches commenting on the evidence and the conduct of the trial. A trial judge of necessity must have some flexibility in its discretionary authority and responsibility to preside over the trial. However, that discretion must be exercised in such a manner that he does not step over the bounds that limit him in the proper conduct of a trial. He must refrain from imposing himself and his opinions on the jury. So where did it leave the court? He says, according to the justices, the solution is the employment of the accepted procedure, which has been used effectively to respond to any type of problem occasioned by a jury during its deliberation. So they're saying, do what we always do. Here it is. The proper procedure is for the court to call the jury back into open court in the presence of all of the parties and their counsel, if they desire to be there, and to reread all instructions given to them prior to their deliberations without emphasis on any of them and without further comment. This procedure will give the jury the aid necessary for them to continue their deliberations without compounding potential problems as the giving of an Allen type instruction is done. So in other words, what this blog is suggesting is that in Indiana, and I'm going to show you something that contradicts it. So we can all guess exactly where Indiana ends up. But what he says is, we don't give Allen charges. Instead, if the jury is having trouble, we call them in and we reread all those instructions to them. Almost punishment, if you ask me. Those can be kind of long, although the ones here were pretty short. We just read them again. And maybe that will sort of prompt things. But what we don't do is tell them that paragraph up there, that there's no reason to believe that the case can be tried again any better or more exhaustively than it has been. There's no reason to believe that more evidence or clearer evidence would be produced. We aren't going to tell them that. We're just going to read them the instructions and send them out again. And so in this professor concluded that judges in Indiana cannot give a typical Allen charge. So that would be really different from what we saw in the Karen Reed case and from what is the case in many states, probably most, where they will give an Allen charge and say, get back in there. Let's try again. Don't give up. You're the guys. Do it now. So that would be really pretty different. And let me show you then the other document I found. as I tried to figure out exactly what the answer to this would be. Okay, stop share. All right, let's see. Is this it? No, that is not it. All right, let's try again. It was also, I think, a tweet, an X. All right, let's see. Let me try again, see if I can find it. No, that's the timeline. That's the screenshot I already showed you. Here, let's head over here. It was, well, I sent it to myself, so I ought to be able to look it up again on my phone. Let me try that. Oh, and thank you to Lindsay for sending me some of this too. Thank you, Lindsay. I appreciated it very much. All right, so this is from the Weineke Law Office, and here's what he said. He cited Rule 28, the one I read to you that talked about what would happen, and he says, and this is how he concluded, is the court required to give the Allen charge? No. Everything is in the court's discretion, as the jury rule uses may instead of must or shall, and we saw that in the jury rule. But in practice, and this is critical, because there is often a difference between what's actually done and maybe what the words say or what people from the outside might think. The following is most typical. The judge will ask the jurors if there is anything the court can do to assist the jurors with the deliberative process. We saw that in the rule. And most likely, the judge will impress upon the jurors how they should try to reach a consensus, if at all possible, which seems a little different from what the prof was saying you can't do that. All you can do is read the instructions all over again. The court usually sends the jury back to continue deliberating. If the jury claims it is at an impasse a second time, the court can declare a mistrial, or it can send the jury back again. This is all within the court's discretion after consulting with the parties. So interesting. Oh, I need to make myself bigger again. So you can see that there seemed to be a little question around the exact procedure. I found sort of two things that I think are different. One says, we're going to tell them, go ahead and keep trying. Both of them have something huge in common, though. The court doesn't give up. The fact that the jury comes back once, that doesn't mean it's all over. The jury comes back once and you send them back out. The jury comes back again and you send them back out at least a couple of times. And somewhere along the way, the judge is going to take an additional step. Is it just reading the instructions, or is it reading the instructions and saying, let's see what we can do. Let's try to all get along. Let's try to come to a conclusion. We got different answers in those two different readings, but what is clear is the judge is not going to give up, and the judge doesn't have to give up. It says she may give up. In other words, she can do these things, but I guarantee you, with the amount of trouble that has been put into this case, with the stakes that are riding on this case for everybody, for the families, for the community, for Richard Allen's family, huge stakes. Absolutely, she's going to keep sending them back out. I don't think it's going to be one and done. Okay, well, if you're having a hard time, well, we'll just give it up and we'll send that to somebody else. So let me go ahead and start answering some of the questions. Here's Michelle. Can't see a hurried scene. The girls' suite. The girls were found. You have to be very clear with me. Anything cryptic, I'm going to have a hard time. The girls were found by the cemetery. I can't see a hurried scene because he saw a van going by. Makes sense. I have so many questions. Yeah, I totally get that, Michelle. The timing is very, very tight, and it doesn't look like a hurried scene. However, I think what the prosecution would argue is I guess they would argue it wasn't even hurried. They would argue there was enough time to get them to the clearing, and at that point, the phone falls. Now, how long it takes him to kill both girls, how long it takes him to arrange the sticks on the bodies, that could be longer. He said something about waiting to make sure that they so that they didn't suffer, to make sure they were dead. So he stayed there a little bit of time, but the prosecution would say, well, there's a pretty good amount of time between 2:32 when the phone stops moving, and roughly 3:55, shortly before 4, when Sarah Carbaugh sees the muddy, bloody guy. And if that's Richard Allen, then he had some time. That's what I think they will argue. Daria is asking about whistleblower case anecdotes. Well, I do have some amazing whistleblower case anecdotes. Some whistleblower cases are under seal for a long time. And so I have some right now that are under seal that I can't talk about, but I have some from past days that I could talk about. So maybe someday on a members only thing or something. It's not normally related to what we talk about here, but maybe people are interested. Thank you, Daria. And I'll get some thought to talking about that. And there are clients no one believes and who are targeted. That's for real. They're clients, not mine, but I do know of people. I have some friends whose clients were shot at and things like that. It can be pretty frightening, but also incredibly important. Deb is a new member. Fantastic. So Inigo is asking, is Richard Allen painted to be more of a bumbling but lucky, evil drunk with no impulse control, or a planned, skilled monster who quickly pulled this off, or both? Well, I don't think that the state has painted him as bumbling, maybe evil, I guess they would go with, although it's not like they brought in outside evidence and said, there are all these things he's done in the past. He's just a really bad guy. They haven't really done that. They just, and so as far as, to be honest, they haven't really done anything with the motive. They're not required to do that. But other than the fact that he seemed in his confessions that they played to just sort of be like, well, I just suddenly did this. There really isn't any explanation for it. And it's not either way. Planned, skilled, there's no suggestion that he planned it or was particularly skilled, other than the fact he managed to do all this in a very brief period of time without the girls crying out. He managed to corral them both, get their clothes changed and clothes off, clothes changed, across the creek, up the hill. He did a lot in a very brief period of time, killed both. Neither of them cried out, all with people around. So it is a lot to ask, but I don't think he's been painted one way or the other just because they didn't offer anything in that area at all. So Kara is asking me about, wouldn't someone with dependent personality disorder not want to be separated from the person they depend on? Hence his adamant denials. Certainly true. He wouldn't want to be separated from his wife. And we learned that he didn't want that. As the defense says, that's part of the reason that he decompensated so badly is when he was inside the prison, he didn't have any support system. So would that lead to his denials? I mean, I suppose it could, but honestly, also not wanting to go to prison would probably lead to his denials. But you're right. Certainly that would be something he'd be afraid of. Brian is a new member. Welcome. What about Richard Allen's 2017 missing phone? That is a fact that the prosecution thinks is very telling. They think when you have a whole bunch of phones for many years and the only one that's missing is 2017, you have something to hide. The defense says, look, he turned over all these phones and suggested, the jury even suggested in that one question, maybe there were other ways the state could have gotten the data. Maybe they didn't have to have the phone itself. Maybe there were ways they could go to the phone company and have gotten some of that. Or maybe when he got a new phone, it all got transferred to the new phone. So maybe it hasn't been lost at all. The fact that the 2018 phone was synced to the old one and all the data was imported, maybe that's good enough. All right. What is the age range of the jury? Bella asked me. And are they younger and older? They do range, but I would say, I don't think there was one really young fella, but he suddenly disappeared one day and we didn't really know exactly why. Still don't know why. And he was younger. The rest of them, I think, nobody's in their early 20s or something like that. There are several older people on the jury, not too much older, but older. But I would say it's pretty much a range. I would say the majority, probably the average age, 40s, something, if you take the average, I would say somewhere in there. But they are really, from their questions, they were really tracking. Also, Sometimes you'll see a jury where some members will fall asleep. They don't really seem to pay attention. That did not seem to be the case here. They seem to track, to listen, to care, which is exactly what you want from a jury. So Stephen is asking a question about the photo of Bridge Guy. The photo of Bridge Guy is a still shot taken from the video that was taken by Libby. So they pulled 2 screenshots from that. Now, there are also some snapshots of Abby, but Bridge Guy is not seen in that photo. It's Abby on the bridge, but without Bridge Guy. Danielle, thank you so much. I appreciate that. Oh, Nita Megapint, thank you. First of all, the name, but thanks so much for the epic coverage. That's so nice. Thank you. I do fully agree with you. Trials absolutely need to be public. That is our greatest protection against the power of the government crushing people and them imprisoning people who don't deserve it or for political reasons. That's how we get protection from that, is we make sure that trials are public. So there is the oversight of that. For time of death, did they check stomach contents? Apparently not, Jay Hancock. They did no cutting or anything on the girls, and they also didn't empty stomach contents. There was at least, I will say this, no testimony about it if they did. They didn't tell us, oh, here's what they ate. There were some questions about that. They'd had pancakes that morning, and there were, not questions, but in the gallery, people wondering, well, they had pancakes. If only they had tested, maybe they would have been able to tell that these pancakes were, they had been digested for 20 hours. So the girls didn't die until 4 in the morning or whatever the answers were. Thank you, Jody. I appreciate that. And Ray Twice and Rebby Lee are both new members. And Rebby Lee already coming in with a super sticker. Thank you so much. So Gamer AI asked, did they test the phone for water or dirt damage? And did they find any footprints? So it is totally bizarre that the Phantom Killer left nothing. I don't get it. No footprints, no fingerprints, no blood, no DNA. How is that even possible? Even the sticks on their bodies, no DNA. Tested for DNA, nothing. They found absolutely nothing. I get he probably wore gloves, but wow. So did they test the phone for water or dirt damage? Not that I know of, and that would have been pretty important. Now, they did talk about, they looked at the phone. At the end, they suggested maybe water or dirt damage had caused that headphone input, headphone output that they saw about 5 hours apart, 5 something and 10 something. And maybe that was caused by dirt or water, but it never really got explained. There was no expert testimony on it. That came from a Google search done in, during a break, and the witness brought it back in. That is hardly expert testimony of any type at all. I can't even believe it came in. And we did have testimony earlier. Nobody was thinking about that phone jack. or headphone jack. So I don't really know, but they examined the phone pretty carefully. I would think if they had seen dirt inside it, they might have even noted that. But since no one was thinking about that at the time, I didn't notice if they said that. I don't remember anyway. What if the phone was put in airplane mode? Would the steps still show? Misbehaved asked. It's a great question, and I don't know the answer. They didn't really tell us that. I think the answer is yes, it would still show steps, but I'm no expert, and no expert came to tell us the answer to that. It's a great question. And misbehaved. Really want to know the answer to that question. So I really double wish that I had the answer for you. Thank you for both of the super chats. I appreciate it. Christina Beth asked if there were cameras on Richard Allen at all times in prison. When there be a recording of his white van confessions to the psychologist? I think that there was no recording during the psychology sessions, at least the ones that were not in his cell, but that were in the cage where he was placed for these sessions. There was no recording there. Also, there was no audio, at least produced, on the in-cell video. And there was no audio allowed on the camcorder video that was played. So I think the camcorder did have audio. I think the in-cell didn't even have it. But one thing I know for sure, it didn't get played. It didn't get played during the court, either on the in-cell or the camcorder. And I think at least the in-cell had none. It was video only. Elf is wondering about the prosecution not testing the height and whether that's on purpose. That was definitely something that was hinted at by the defense. They said, how much would it have cost to get somebody to come in and compare, okay, here's the bridge, we can measure that. We know how big the bridge is, it's still there. And let's compare that to the man. Let's put him in the exact spot, standing on the same timber that goes across. Let's make it just right. Now, how tall is that man? And the defense said, wouldn't that have been useful, to have had that? But the prosecution witness said it would have cost $10,000. It was going to have a range, I think they said, of about 2 inches. So it wasn't going to be absolutely on target. And so they decided not to do it. And the defense clearly making the point, well, it sure would have helped us if you could have proven the guy was 6'5". That would really have proven that it was not Richard Allen. Oh, thank you, Candace. What a nice note. I appreciate that. Cindy, I'm with you. I'm just mystified. They did do tons of DNA testing, and yet they never tested the hair in Abby's hand that had a root that could be tested for DNA. It's a common thing that hairs caught in the hand may be from somebody struggling during an attack. So, they look at the hands, they pull out the hairs and they look for that. And here it had a root and it could be tested. And yet for 7 years, it was never tested. It was tested right before trial started. We got the result in trial, and it was the sister of Libby. Now, the prosecution suggestion for why that would be is that there was that the sister had driven the girls to the trails that day and loaned her sweatshirt to Abby. So when Abby maybe took the sweatshirt off, or maybe when Libby did and gave it to Abby, I've forgotten who was wearing it. But when that shirt came off and got handed to the other girl, then maybe the hair got on the hand then. That was the suggestion. But the fact that it wasn't even looked at for 7 years, I don't get it. I find that really, really confusing. Crystal Trickle, thank you. I appreciate that very much. And friend of St. Frank, thank you again. I appreciate that. Definitely. Jet Wilson, do I think Richard Allen sounds or looks like Bridge Guy? So I do think at the time he looks a lot like Bridge Guy. I felt like it was impossible to tell on the sound because it had been altered and run through computer stuff. So I felt like that was really hard to tell. I did feel like, though, he looked like him at the time. If you looked at the pictures, his size and sort of, how thick he was. There weren't the pictures. They introduced 4 of them. You can find some pictures on the internet. I don't know what 4 they showed the jury, but his daughter said, yeah, that's what my dad looked like in about 2017. So I would like to have seen those. They were handed to the jury, so we weren't actually shown those. But from stuff I saw on the internet, I thought, well, could be. But you do have to remember this. They got 14,000 tips. That's crazy, right? 14,000 tips. And in all of those tips, the only one that was Richard Allen based was the one from Richard Allen. Whereas they got tons of tips on other people where my ex-husband looks like Bridge Guy and sounds like him, and my current boyfriend or whoever, all these people and their families, my neighbor, my teacher, all these people who had some kind of, in somebody's mind, looked or sounded like Bridge Guy, and they would turn them in or offer a tip. I think it could be a connection because the police were asking for tips. They wanted help. And in all of those, nobody said Richard Allen. Why, by golly, that sounds just like the guy at CVS who handed me my prescription. That really sounded like him. Nobody said that. So interesting. Oh, thank you, ma'am C. Keeman. I appreciate that. Melissa and Caitlin. Good to, it was good to meet you. Thanks for coming up. That reminds me, I do want to say hello, give my shout out. I met a ton of people today. Heidi from the Boot Hills, Ring the Candle, Dave and Linda and Lucy Ball and Marcy and Erica and Rain. And Michael Thomas. I met so many different people today. Mike and Mark and Chris and Danny. I met a ton of people today. Oh, here's another grandma of 6. Chloe. There are a bunch of line sitters that I'm leaving out. I'm really sorry about that. I'm going to stop there because that's a bunch of names. But anyway, it was really great because a lot of people were coming by today as we're waiting for the verdict, just to kind of come by and, be there in case something happened, or just to be there. It was so nice meeting so many people from around the area. I have just met the loveliest, kindest people. It's just been a real pleasure to meet some of the people from around here. Really, really nice people. Certainly, whoever committed this crime has very little in common with all of the people I've met. A really, really different kind of person. GMA of 6. Is that the same grandma of 6 that I met today, I wonder? Glad you're a new member. And Shannon, glad you're a new member as well. Stacy is all in on Richard Allen not guilty beyond a reasonable doubt. And I think certainly sitting outside the courthouse, I would say there are more people in that camp than pro-prosecution, but I'm not sure that that's true, in the community as a whole. That's just who happens to be who was at the courthouse today. All right. Why? This is a very good question that Jolene asked. Why isn't the defense allowed to say they're limited to the funds the court allocates to them? That seems very important for the jury to know. I don't know why they didn't do that. I don't think that they were necessarily prevented from it. I thought one option would have been, and I don't think it would have been ruled out or improper, but I thought the defense lawyer could have said, after the jury said, why didn't you do a report? The defense lawyer could have said, what would it have cost to do a report? You charge for doing reports, right? And what would it cost? How many hours would it be? How much do you charge per hour? Maybe they didn't want to get into the whole how much it costs, how much you charge. Maybe they were afraid of doing that. But it just seemed to me, I agree, since the jury was right there asking that very important question and sort of implying that the fact that this report wasn't done, what does that mean? Does that cast some doubt on your theory? And so I felt like they maybe should have asked that question. I thought it was pretty relevant too. And I would have tried to show that to the jury. I could be wrong. Maybe there were other reasons they didn't do it. Or maybe that was one reason, but there were a bunch of other reasons that also factored in. So maybe that wasn't something they wanted to ask because it didn't come first to mind. Maybe there were some other factors that they had considered. Crystal asking me about whether I would be a guest on Hidden True Crime with Lauren and Dr. John. They're great. I got to meet Lauren here, along with, she's had several friends with her over time. Right now, Grayson and Lindsay, I got to meet her friends and met friends that she had before. Lori and Christina were here as well. And it was a great pleasure to meet all of them. I'd love to do any collab with them. Had a really good time talking to them and meeting them. I feel like I'm missing someone else who was here. My apologies if I've forgotten one person who was here. But anyway, it was great to meet them. Ray twice. Thank you so much. Elf is a new member. That's great. Thank you. Susan asking me, if Richard hadn't come to the police to let them know he was in the part that day, they probably would not have ever found him to be a suspect. And I was hearing somebody saying today outside the courthouse, well, now I tell my son, whatever you do, don't go to the police. Don't talk to the police. That's kind of sad that would be the takeaway from this, is that whatever you do, don't go to the police. But this is absolutely correct. If Richard had not self-reported himself, no one was going to point the finger to him. Of course, at the time, let's say he actually had committed the murders. He doesn't know that nobody's going to come forward and say, Richard Allen either looks like Bridge Guy, or I saw him at the park that day, whatever, told me he was headed over to walk on the trails. He wouldn't really know that. So typically I would have said, good idea to get ahead of that, but it certainly didn't work here. That's just a fact. This forensic SC investigator asks, has anyone talked about that cap? We know Richard Allen had jeans and jacket, etc., but what about the cap? Nope. There was no discussion about that cap. I don't think that was placed in evidence or a picture of it. At least I don't remember it. I hope I'm not wrong on that, but I remember nothing about the cap. Could he have thrown it away because it was unique? I guess maybe that's the implication, but we didn't see that. There were some pictures when you would look at it and you'd think, is that just hair? It's like poofy hair. Remember there was talk about the guy with the poofy hair. Maybe it was poofy hair and not a cap. One witness was asked that. But I don't remember seeing a cap that came from the search of Richard Allen's home. All right, where was I? Okay. Jet. For room service department. Thank you. Thank you. I appreciate that. That sounds great. Thank you so much, Jet. Could they request a new judge to help them reach a conclusion? Bella asked. Not in the middle of a trial. I mean, this is the judge who has conducted the entire trial. The evidence is over. All that's done. Like, I don't even see how they could open it up to let the jury go see. I don't see how they, maybe if everybody agreed to it somehow, but the evidence is over. The case is concluded. Right now, it's just the jury deliberations, which are to remain inviolate, just a separate contained event. So there's not anything to bring a new judge into. That there are small rulings here. After appeal, that's a different matter. It is possible it could be remanded. Normally, when you send the case back, if the case is reversed on appeal and goes back for a new trial, normally it goes to the exact same judge. Could something different be done? Maybe. I mean, I think the appellate court would have the power to refer it to someone else. Judge Gull could say, look, I did this once. It's somebody else's turn. And certainly you could hardly blame her. And, you know, it could work out differently for a different judge. But the normal way it would be done is it would be sent right back to Judge Gull to be tried again, but with some different rules. Whatever the new rulings by the appellate court were would be applied to that case. All right, Lucy Barnard is a new member. That's great. And Starlight, thank you for the super sticker. I appreciate that. Matt Spunky has been a member for 7 months and is thanking the mods and all of you fellow chatters. And I want to thank the mods too. Marlon has been such a help to me so many times. I want to thank Denise Pelton, who is our newest mod, and also Mama Pinks, who's taking a little break right now, but will be back with us soon. Donna E., thank you for the super sticker. And Aries is asking me about, if found guilty, if the jurors later see all the evidence that was left out and not tested, et cetera, is there anything they can do collectively? Because I'd be livid if I felt like I helped convict an innocent man due to others' negligence. There really is nothing that the jury could do. And what the jury is asked to do is make a decision based on the evidence actually shown in the trial and nothing else. It's not the jury's responsibility or even ability to worry about what was actually done before they even got the case to take evidence out and so that they never saw it. That's just not their job. They can't deal or worry with that. I totally understand what you're saying. It would be very upsetting to think, well, gosh, if I had known about this or that, I would have voted differently. But that's the argument that then goes up on appeal. That's what the defense will say is the jury might have voted differently if only they had known about all these third-party culprits. If they had known that the geofencing data showed other men were in this area, if they had been allowed to see these facts, it would have proven that, or at least it would have convinced them that Richard Allen was not guilty beyond a reasonable doubt. So all of that would definitely be on the appeal. And the jurors, unfortunately, just have to live with the fact that they were given limited facts and understand that that's the way it is. And it's not their fault or their responsibility. They only make the best decision with the data actually given to them. But it's also why it's so critically important that the best, most relevant information go into the jury, because they can only make a decision with the evidence they're actually provided. They can't make a decision based on information that's withheld from them. So that's why those are such critically important issues. And that's why the judge has so much authority over the case, so much influence over the case, because the judge is going to make those decisions about the evidence, and they are going to change what the jury knows. And when you change what the jury knows, you change what the jury does, at least potentially. Interesting. Can a juror ask for the analysis of BG's height if a verdict can't be reached? So I have never heard of that. In cases that I've either handled or know about, it's always been the case that when the evidence closes, that's it. No additional evidence goes in, period. The jury doesn't visit the scene. No witness comes back. There's nothing. I had never seen something like in that rule that I showed to you, the Indiana rule that said, hey, we're all going to discuss it. Well, let me get the exact wording was, they would inquire the jurors to determine whether and how the court and counsel can assist them in their deliberative process. That seems really open-ended to me. I don't know how it's been interpreted or how Indiana applies that, but it sounds like it could be various things that might help the jury. I'm fascinated by that. I've never seen it before, and I don't know if in practice that really happens. Thank you, Lucy. I appreciate that gift very much. So, back to Grandma Shell. I didn't ever answer her question. I got off on a tangent. Can a juror ask for the analysis of the height? I don't think so, because it wasn't in evidence. So I think they have to just stop right there, and that'll be the end of it. And thank you, Lucy. I appreciate that very much. Bill, this will be a hung jury. Bill is making a bold prediction. Is Indiana a state that will release which way the jury leaned? I do not know the answer to that, Bill. And it may be, typically I wouldn't expect to get that unless a juror comes out and says it. In most states I know of anyway, the jury will be told, you never have to talk to anybody about what happened. What you do is up to you. And then sometimes a juror will come out and say, well, it was 3-9 or 6-2 or, well, not 6-2, 6-6, whatever. And in this particular case, I don't know what Indiana's rule on that is. I don't know if they're allowed to. I assume they can't be prevented from talking to the media. And by the way, let me say, if any of you know of someone who's serving on the jury, I would love to interview some of them, one or more, to talk to them about what were some of the pieces of evidence that really were persuasive. What shaped the decision that they made? I would love to talk to them. Please, please let me know if you know of somebody. Put them in touch with me. Okie dokie is asking about if it will be interesting if convicted what the jurors make of all the evidence. Right, that's exactly what I'm saying. And additional information that was not allowed in. Would they have recourse to take any concerns back to the judge? No, they would not. That will all be something that would go up on appeal. There's nothing they can do to affect or change that. Nas M is asking which one died first and is Alan's alibi solid? So he doesn't really have an alibi at all because of the fact that he places himself at the trails in the park at that exact time. Originally, he placed himself there between 1:30 and 3:30, which would be the exact time. Later, he said between 12 and 1:30, which would not be the correct time. So there was some discrepancy there. And we do not know as far as how the actual murders occurred. Milky Joe, did JG tell Judge Gull, tell the jury, hey, I got one. They can only watch video evidence one time and only in the courtroom. See, I did think she said that. But then later I was debating with myself about whether or not she had said, I'm only going to let you show it to the jury one more time before the close of evidence, which is what they did. They showed it one more time, or whether she was saying the jury will only be allowed to see it one more time and they will not be allowed to see it again. I didn't know the answer to that, but I know I would want to see that a lot more. I would really want to understand it. When I initially reported on that, what I had thought she was saying is the jury could only see it once. They would be allowed to ask one to see it while they were in deliberations, but they can only see it once. I just don't understand why would there be a limit on that, though? I mean, if they wanted to read over a contract 20 times, would she stop that? So I don't understand why it would be limited when it came just to the video. All right, where was I? Milky Joe. JP, thank you so much. This is a good point, Inigo raises. At least if there's a retrial, the defense can call the FBI agent. What the heck was he going to say? So what the FBI agent would have said, and they kind of got this in with questions, is that Brad Weber told the FBI agent, along with someone else doing the joint interview with him, that he had not gone straight home. He had not driven his van home, so he was not there between 2:27 and 2:30. Instead, he first went to check his ATM machines and service them, and then he drove home after that. If he doesn't get home if he doesn't get home until even 3:45, it's too late. It's too late for what his van does to fit into Richard Allen's confession, because according to the state, they're already in the clearing where the bodies were found. It's not really even a clearing, the woods in the area where they were found. They're already there by 3:32. The phone is lying on the ground there, and it never moves again. Are the girls dead? We can't really answer that, but certainly the whole process has begun, and that doesn't seem like it's related to seeing the van. So if it's too late, then that confession is invalid. So that's why the big fight over that. But that's what he would have said. I think he would have said, here is my report that I issued, and this is what Brad Weber told me. He told me he first went to service his ATM machines, and only then did he come home. Now, there were two people there, and they asked the other guy, and he looked at the report. It was really pretty frustrating, which clearly had a sentence in there. He told us he went to his ATM machines. He goes, yep, I refreshed my recollection. So did he tell you he went straight home? Yep. Or I don't remember. I can't remember exactly how he phrased it, but the bottom line was he was not saying that ATM thing. So Cosmic Shy, thank you. Appreciate that nice email or super chat. Does the judge limit what the jury can say in deliberations? Not really. If by that you mean what they say to each other. If they come into the courtroom, it'll be normal court procedure where the forum person will talk for the jury, and it won't be just everybody chatting with the judge. It's not going to be like that. It's going to be a formal proceeding. They'll be seated in the box. She'll be seated at the chair where she normally sits behind the bench. It'll look like a courtroom layout. They probably looked at evidence in the courtroom. She had made arrangements for that to happen. So that's probably where they were when they looked at the evidence. Assuming they did. I'm assuming that what we read on and heard was true, but I guess I don't know that for sure. Gingy Probs wants to know, which piece of evidence do most pro-guilt folks cite to support guilt? And if Richard Allen is bridge guy, why does that mean bridge guy is the killer? So I think this is sort of the way the argument ran. As far as the evidence most pro-guilt, to me, it's the confessions. I think that overrides anything with the gun. To me, the confessions are the most important. If Richard Allen is bridge guy, why does that mean bridge guy is the killer? I think the only reason that that's believed is because of the timing and the video. Libby's video, when it was taken, when the phone stops moving, and the fact that the words even that are said, we couldn't hear all of them, but we got the interpretation from one of the prosecutors about what it meant. XXDF. So state's case is Richard Allen brought knife and gun from his mom's house, had 3 beers, and killed girls. Yes, that's pretty much it. He was spooked by a van, but not by many people he met. True, although he met people before he took the girls, according to the state theory. He kidnapped the girls, abducted them from the end of the bridge, and there weren't people around right then. But yep, that I'd say that would be correct. Job Trice is asking me, the prosecution should have let the defense speak of Odinism. It may have made the defense look less credible. And that is, and let me finish, as jurors can interpret it poorly and hurt the case. One of the reasons I think that the judge needs to let in this third-party evidence, I think there are a host of reasons. One is legal. I think he had a right to present the evidence. I think there was a nexus between the various third-party culprits that he wanted to talk about and the crime, just as much of a nexus as there was between Richard Allen and the crime. Also, though, one of the problems with any resolution of this case is that there are going to be people who don't believe it. certainly that's always the case. You're never going to have everybody think, oh yeah, I totally agree with guilt, or I totally agree that with not guilty. You're always going to have disputes over that. But it's the disputes here are very deep. I mean, these are chasm level disputes where many people believe that Richard Allen wasn't given a fair trial, where many people believe, and if this evidence had been allowed in and you took away that argument that there's not a fair trial, if the judge thinks it's so preposterous, it could well be that the jury will think that as well. I mean, I think that's a really valid argument. I think it would have been better for people accepting the verdict, and I think that the jury might well have rejected it. The jury might have said, there's just not enough proof. I don't see this. I don't see any connection. It's not casting reasonable doubt for me. That could have happened. All right, let's see. Where was I? Was it Job? Oh, there we go. Thank you, Jim Bob. I appreciate it. This one is a nail biter. I think this is a very hard case, but it's very, with people on both sides of the issues who really disagree, strongly disagree. And I am, to be honest, I'm a little surprised that it appears the jury may be that way as well. And the reason I'm surprised is because of the fact that so much evidence was kept out. And my impression of why there's such a divide is that there's a lot more evidence and information outside the trial than there is inside. So part of the belief that he's not getting a fair trial is based on the idea that there's evidence out there that we know about and that's not being shown to the jury. But if the jury itself is struggling, they aren't totally out of the realm of just, it's time for us to look through the evidence. Somebody told me that, I can't remember who even said this to me, but maybe it's like an hour per day of testimony. So they're just now kind of even hitting that, like 7-14. They went short both days, really, but they're at 16 hours. I think there were 17 days that were direct testimony. So that's, maybe about right. Maybe about now they would be deciding. So that's not totally out of the realm of possibility. But I would guess that it indicates some struggles. And I base that in part on the questions I went through with you, where I tried to show you, some of those questions suggested pro-prosecution, some were pro-defense, and maybe they're really struggling around some of those 4 issues we talked about. All right. 6 months as a member for Gingy Probs. So glad for that. So glad. Good to have you. Invisible 444, thank you for the coverage. Well, thank you. I'm glad you're enjoying it. And Racing Queen, I appreciate that. ATM says, yes, the automatic teller machines. He had machines where people would put in a card and get out money, and what he would do is add money, so that he said, well, you don't make a profit, or I think the cross was, well, you don't make a profit unless it has money. And yes, that's right. He had to keep it stocked with money. Deanna is asking about whether the jury being sequestered and having all their communications and activities monitored may make them sympathetic to Richard Allen's conditions while incarcerated. Well, that's an interesting question. I guess it's much better conditions, but certainly it might make them think. It might make them think about how difficult it can be. That's a really interesting point. How many of the 61 confessions were audio recorded? There were 7. Corn Doggy asked, and I think there were 7. They were recorded phone calls to the wife or to the mother of Richard Allen. There were written notes by the guards. There were written notes by Monica Walla, but the audio was of those. I think it was 7. I think that's correct. Danny, thank you so much. Shell, never given a super chat before. Well, I'm especially honored. Thank you. Thank you so much for my Diet Coke fund. Thank you. I was using that Diet Coke fund today, so thank you very much. Genzo33 is a new member. Welcome. So Idiot Wind is asking about, what about the call to the mother seems so compelling to you? Consistent to Idiot Wind with negative symptoms of psychosis and impeachment. Video of D-Mart have swing. How you feel? Impeachment video of, I'm telling you, you can't be cryptic on me. I'm gonna have to type everything out. I can never guess. D-Mart have swing how you feel. I don't know. I'll go ahead and answer the other part. So what about the mother seems so compelling to me? I wish I could play it for you. I really, really wish I had the audio because it was the sound of it that was compelling to me. It was that he sounded very calm. He sounded very rational. He responded to her correctly each time. She would say, she'd say, we're not going to talk about that. And he said, and it was just the way he spoke of it. That was what to me made it sad. I don't think I have the script of it right here, but and it was his response when she said something to the effect of, just because you speak it doesn't mean it's true. Doesn't mean you did it. And he said, it is if you did it. And it was so matter of fact. It was just so responsive. He had already made comments, especially with his wife, that mirrored what their defense expert had said would happen, which is if you're creating a fake memory, it starts with the thoughts like, I think I did this. I might have done this, and then moves into pictures and becomes the fake memory. And he had started with that. I think I might have done it. So it's not out of the realm of possibility that he was creating this fake memory. But if you heard it, it's just the way it was said and the words and just the way it sounded, the way he was responding to her. That was what was so made that one by far the hardest to me. And anyway, I feel sure that the audio will get released at some point, and then I'll be able to tell you about that. Job Trice wants to know, how many times can Richard Allen be legally tried if juries continue to be hung? How long can they keep him in jail, and when does it stop if there's no plea deal? There is, it depends. I can't answer for Indiana. In many states, there's no limit. You could continue going. Some states do have limits. Typically, a lot of the decision is around the resources available, the seriousness of the crime, what the victims want to do. Those things all have to be taken into account. So for a very serious crime, prosecutors are more likely to try it again, fairly obviously. In this case, we have heard that it cost $4 million so far to try the case, and including both the defense and the prosecution, which both have to be paid by the public, the courthouse, and it may well have cost them way more than they imagined. The state police will have incurred costs, and of course, Carroll County will. There may be other organizations, for example, guards and so forth in Fort Wayne. They may not have been paid any more, or maybe they didn't have to do overtime, but they were certainly involved when the jury selection took place up there and hearings take place there. So there are a lot of moving pieces, and the cost has been high. Is there money to do that again? Is there political capital to try somebody again when there's already been one loss? Or now what about two losses? What if there were three? At some point, obviously, there's going to be less of an appetite for that. But there's, in states that I know about, there's not a specific limit. But there may be here, and I just can't answer that. Starlight, having just finished doing exactly that, Starlight Selenite says, I love that you debate with yourself. Yes, I definitely do. Debate everything. Yes. So L Waters is saying someone went into a chat with my picture and name. Well, that's rude, and it wasn't me. As I'm live. Well, clearly not. Clearly not. There's a character reference. It wasn't me. Well, that is really seriously disappointing. Maybe you can tell me later where, maybe you can contact me and let me know where that happened. I'm disappointed to hear that. That's a shame. Amy asking me, please tell us you will cover a retrial if hung. Well, I will certainly give it some thought. I guess we'll have to find out what happens. Like, will it be reset? And if so, when, and that kind of thing. But thank you. I appreciate that you would want that again. Is there any part of our government to address pretrial tax? First of all, Karen K is a member for 8 months. Let me say thank you. I'm really glad about that. Or it could be any part of our government to address pretrial taxes. Pretrial taxes? I am telling you, you cannot be cryptic with me. You're going to have to write out every single word. I'm sorry. That is just the way it is. Beth is asking me, did BW give the ATM alibi. Oh, BW. Somebody said BW earlier. Brad Weber. Duh. Okay. Give the ATM alibi prior to knowing they were looking at Richard Allen. Yes. And if I had to guess, if Brad Weber is telling the truth, then I wonder if he added the ATM alibi because that maybe it was known what time the video was taken and he was pulling himself out of the area during that time by talking about the ATM. That's total speculation. I don't even know that he knew what time the video was taken, but I wonder if that would be his explanation for why he added the ATM when he was talking to them. He might just say, no, they made it up. I didn't say that. I have no idea what he would say, but it'd be very interesting to, to know. He was adamant that, no matter what I said, they talked about how he had brought proof and we didn't see what that proof was. What proof did he have? I don't know. They didn't present it. They just talked about, oh yeah, he brought proof to the station. So we were able to tell that he had actually come straight home instead of going to service the ATMs. But what kind of proof would there be? If it's that he clocked out of work, that's not proof that he came straight home. So they referred to it, but I asked around and we all agreed there was no evidence that was actually presented of that. Sean, thank you so much. I appreciate that. And Irene, I appreciate that as well. Corn Doggy is asking, could the psychologist record their sessions? I think it would be really inappropriate. But then I also thought it was inappropriate that the psychologist can read notes of a session with Richard Allen. And to me, that just seems wrong. It seems like that ought to be private and confidential, but it was not. And so could the psychologist record the session? I mean, maybe it wouldn't be wrong to record it, but then to play it at trial, that's really the bigger issue. Not just could the recording be made, but what could be done with the recording. Linda, thank you for the super sticker. I appreciate that so much. And thank you, Kim. I appreciate that as well. Idiot Win is now going to explain this for me. I'm sorry about that. I mean that the video you saw when he was in clinic exhibited negative symptoms of psychosis, and the call sounds to me to also to exhibit negative symptoms and time proximity between that video and that call. Okay, so let me think through when the call was made. So the video, we didn't actually see, we did see a video of him in a medical clinic. I don't think it was in the meeting with the psychologist, but we did see a video of him in a medical clinic of some sort. And he was definitely, his head was lolling about, he wasn't speaking. I did hear someone say that they saw him track somebody as they walked by as if he were really more awake. I didn't see that. It's the kind of thing where if I saw it again, I would sure like to look for that, but I didn't notice it or see it. But as far as, so those were negative symptoms. And on the call, there were various calls. On some of them, there were true negative symptoms where he seemed confused or he would say things that didn't make sense and kind of throw them in. The exception to that seemed to me to be the grandmother call, the mother call, because it just didn't seem to have any of those extraneous things that got thrown in. It was just a straight up confession. And he kept at it. She would say no. And he didn't say, well, I think I did. None of that. He was like, yeah, I did it. No, I really did do it. And I wouldn't tell you that if I didn't do it. That was, I think, how he ended. I wouldn't say that if I didn't do it, if I didn't mean it, if I didn't really do it. And so I thought it sounded different in nature from the others. And I wish I could play it for you and you could decide for yourself. All I can do is tell you sort of what I heard. And that's subjective, right? It's how I perceived it, but might not be how you perceived it. But as far as the time frame, I don't remember exactly when it was. Do I have that? I might be able to. I don't. They showed a bunch of camcorder video to the jury. So I don't know. I'd have to really think through that. I don't know how far apart they were, Idiot Wind. The grandmother's call. See, dang it. That's exactly why I have that darn timeline, right? Not the grandmother, the mother. Okay, his mom was on April 2nd of 2023. And then that video that they actually showed, They see the one they showed video right around that to the jury. So let's see, there's the mom confession. What did I say that was? 4-2. Okay, yeah, that was 4-2. So the first camcorder that they showed to the jury was 4-6. So 4 days later, they showed a camcorder walk around video. I didn't note specifically the one that we happened to be able to see. It was a repeat of one that the jury had already seen, but I didn't write down the date. Probably should. That's an interesting point. All right, Lyndon, thank you. I appreciate it. I have to say, I am looking forward to home. There's no place like home, right? Cryptex, thank you for the super sticker. And Just a Friend 13, what was the defense's explanation for Richard Allen knowing about the white van? So it's super interesting. While everyone has talked about the white van, listening back over what was read by Monica Walla, the word white wasn't in there. It was only van. But repeatedly, we heard throughout the trial about the white van. Where did the color come from? I don't know. But the defense's explanation, not true evidence, but through questioning, was that there were a lot of references to vans that were around this situation. They weren't vans that drove the murderer or anything like that, but there were, when everyone was searching diligently to try to figure out who did this in the days following the murders, there was someone driving a van, some sketchy guy who was handing out candy to children, and that became suspicious. So maybe that was the van that popped into his mind, that there were references to vans throughout all of the Reddit and chat groups that had gone on about what was happening in the Delphi murders case. And that maybe Monica Walla took that back to him in the forum of explaining to him, many people think it wasn't you. Many people think it was some guy driving a van who tried to give out candy to children, and that somehow, without actual proof, they don't have a specific time when she said that, or even an admission from her that she did say that, but that somehow it filtered back, it got to him. I had thought they might put someone on the stand to say the following 25 documents were given to him, and there was a picture of a van on page 32, something like that. That didn't happen, and it may be that it would have opened doors to questioning about the relationship between the client and the attorney. Maybe that was too risky, but they didn't do that. So there wasn't a really specific explanation for that. Just a friend. Janudi asked a very good question that I was asking around about today. If he gets found guilty, do they sentence immediately in Indiana? And if not, will I be back for that bid day? I probably will not be back, but we'll see. I understand there's usually a break, that it's not right away, but that there's some time. So I say that having heard it, not having known it because I practice here, but that's what I understand. Thank you, Kay Oakley. I appreciate that very much. And J.A. Hawk, thank you. Why did the detectives not go to prison for interrogation once Richard Allen started confessing? So I think the interrogation was separated by a significant amount of time from the confessing. So in the interrogations, Richard Allen denied that he had anything to do with the murders of Abby and Libby. He was very clear on that. Had nothing to do with it. Not there, not around, wasn't going to confess. You couldn't make him confess. Don't try to make me say it. I didn't do it. So I think there was nothing coercive about those interviews. I don't think the defense is saying they were. In fact, the defense asked the jury to go back and watch those because they felt like it was such good evidence that the defense was wanting the jury to see those, because it really showed they believed that this is just how an innocent man would act. An innocent man would deny involvement and just be pretty calm about it. Like, I had nothing to do with that. What's wrong with you people? And they say, yeah, that's what was happening here. Excuse me. So I would say that they aren't concerned about that. They feel like those were fine. Then the confessions, as they call them, were voluntary. By that, I mean, nobody was interrogating him. Nobody had a pen and paper. Well, they did have a pen and paper, but it was guards who were writing down his comments just everything he said, he was on unalive watch. It wasn't them, at least supposedly, wasn't supposed to them. So, Richard Allen, did you do it? Tell us everything you know about the crime, Richard Allen. It wasn't, there was no questioning of him. They were simply, according to their testimony, writing down what he stated. And he voluntarily stated these things. So for that reason, there's no one really at issue for wrongdoing in terms of questioning of him. So it's at least as far as I'm aware. All right. So we have gone super long. I will take just a question or two. If you will put question marks at the beginning of your question, that would be help me find it in the chat. So put several question marks at the beginning of your question, and I'll know that you're asking a question. I'll just take a couple because we've gone super long tonight. I try to keep these short. I've not been succeeding as well as usual here in Indiana. Okay. Bella asking, what about double jeopardy? Double jeopardy will apply if the person if it's actually, there's been a verdict in the case, but that hasn't happened. And if there's a hung jury, there's not one. So in that case, it's not double jeopardy where you try the person again for the same case. It's still the same case. It's not like the case ended, the person was acquitted, and now you're going to try him again. This would be, you didn't reach a verdict. You never got all the way to that stage. So you're still in the same case. You're going to try it again with another jury. So it's sort of a different status, I guess you would call it. Lee, may we see the Libby and Abby candle close up? Well, let's see. Where did I have that? I think it's right in here. Yeah, it was real cute. Oh, you know what? It may take me a little bit to find it. I'm going to have to go look for it. I think it might be in my pocket, actually, in my coat. So, but I will. I'll show you that. I'll put it out here so I remember to do it the next time. Good question. Itchy Withers Horse Rescue. Do you get a feel from the families if they feel Richard Allen is guilty? I think they do. I think they definitely feel that way. They may have some questions after they've been in there, but I feel like the prosecution would have been very clear with them. We are pursuing this person because we believe he's guilty. I am no doubt that the family said, let's make sure we just do this once. Let's get the right guy. Let's make sure we are pursuing somebody you actually believe did it, because you've had a whole lot of suspects, and that the prosecution really believes that and told them that. So I would think they do feel that Richard Allen is guilty. I imagine they feel pretty strongly about that. And no matter what happens with the verdict, it's going to be emotional in the courtroom. If the verdict is that Richard Allen is not guilty, many people will think that's the right decision in terms of the burden of proof and in terms of whether he was guilty beyond a reasonable doubt. And that will be a day of rejoicing for the Allen family. But kind of imagine, just picture what it would feel like for the families of Libby and Abby, who believe that he killed their children and in a horrible, evil way, and is now getting away with it and is going to walk free. I mean, it's going to, no matter what happens, and then reverse it. Richard Allen is found guilty. The families, they won't be happy because it's a horrible event, but they will at least be convinced that it's really, they will see it as justice. On the other hand, Richard Allen's family will be devastated because it will mean that he will be spending life in prison absent some kind of reversal on appeal. So either way, it will be a time that will be very difficult. Autumn Zirkle, couldn't Libby have put the phone in the shoe while she was undressing? Why do they assume the time of death was when the phone stopped moving? It is possible, I guess, that and I don't think they would assume it's exactly at that time, but real close to that time. Part of the reason they think that is because Abby's body was found on the phone. But, the phone could be, the phone could get dropped, then Libby gets attacked, and then Abby gets attacked on top of the phone. So it could still be in that order, but they do think it's pretty close to that time frame. But there are questions all around that, as you point out. Was Weber's phone data extracted? I don't think so. That we didn't get anything stating that, proof that he had driven by, location data. We didn't get anything like that, Ross. So I guess they did not. Why didn't Richard Allen see the bridge guy or the murder girls? The murder girls were a ways off. So, and according to, if he actually was there more in the 12 to 1:30 range, he wasn't there at the time they were murdered. Even if he was there later, they were murdered a ways away, so he would not have seen them. He might have seen bridge guy. That's a possibility, but I suppose they could have just missed each other. What clothes were found in the creek? There was a shoe, an orange scarf, the tie-dyed shirt that Libby had been wearing, and there were some other things. Those are the ones I can remember. Those are the ones I can remember. What was the time of death established by the coroner? No clear answer was given on that, and it would have been very, very useful. They gave a range of like between the 13th and 14th. I think it was really that broad. I think that's what it was. So, wow, that's really difficult to, that isn't really pinning it down. All right. I'll answer these couple over here. Valencia's mom, the confession to his mom sounded like a question. Why would I tell you I did if I didn't? Because he was psychotic. Valencia's mom, there were some of them that sounded like questions. You are absolutely right. Several of them sounded that way. That one comment, I didn't hear that way. And remember, I'm hearing it once played. They did play that one the second time. So I did hear that one twice. But I'm hearing that, we're far back. I could easily miss something. But the way I heard it was, I wouldn't tell you I did it if I didn't, without the why and without the question mark. To me, that was the most important confession because it did seem, it seemed to have more clarity around it than any of the others. All the others had exactly what you're talking about, kind of the questions or something that sort of undermined it. And then that one, which they played last, they had trouble with it. They didn't play it. And then they played it last. And it seemed to be their most important one. That was how I interpreted it. Yaib Trice is asking, if you're tried for attempted murder but found innocent, can you be tried for murder if the victim dies after trial from the injury? Are you trying to ask me a law school question there, Yaib Trice? This is like a law school exam. So it is, if somebody, and I actually had a case where we had a victim who was in a car wreck and she was really badly injured. She was basically brain dead, and she was in what is called a locked-in syndrome. So she was not able to move in any way, in any respect, and she was in a nursing home for many, many years. There was one case while she was alive, and that particular case could be brought within the statute of limitations. We brought that case. We got a very large verdict for her in that case. Then years later, she died. That then triggered another statute of limitations for her death, separate case. And the first case had only settled the part where she had been injured and the damages from that. And now there was a death. So there was a new case. So it is true that the two can be separated, that the attempted murder could be separate from the murder after the person dies. So as far as that particular question, I don't know the answer on that. You asked even more detailed, and I don't know your answer. Sorry about that. Me, passenger, have they ever said why the search stopped at 2 a.m.? No, not really. I just assume they decided it's dark. We've tromped around everywhere. We don't see them. We're going to come back in the light and try again. That's all I can figure. But no, I don't know why they stopped. And it is kind of a question that I wonder about. I just don't know. They were back at it 5 hours later, though. They were all out there, 7 a.m., maybe 7:30, and they were tromping through the woods again, trying to find the girls. And they did. By about noon is about when the bodies were found. All right. Well, don't forget to hit the like button and the subscribe. I will see you at 7 on Monday, unless the jury is out and we've been kept late or something like that. But normally I go at 7 p.m. Eastern time, and I will look forward to seeing you then.